This is Duke University.
I welcome you to this conference pertaining to the recent developments of patent law in the US and Europe. First of all, I would like to thank our speakers to take the time to address us in their busy schedule, and I thank all of you for your interest. In today's global economy, intellectual property plays an increasing role, and its landscape is changing. Given the scope of these changes, in particular the imminent entry into force of the amendments of the American patent law, it seemed appropriate to set out and compare the state of play of those changes in the US and in Europe. Professor Arti Rai will begin by presenting the main changes in the American patent system. Professor Rai is an internationally recognized expert in IP law. She served as the administrator of the Office of External Affairs at the USPTO from 2009 to 2010. In that capacity, Professor Rai led policy analysis of the patent reform legislation that ultimately became the American Invents Act. She is therefore extremely well positioned to give us the most clear outlook of the recent changes. After having presented the innovations brought by the AIA, we will hear from Ms. Elizabeth Fuller on the European Unified Patent Court and the upcoming unitary patent system. Ms. Fuller is a practicing US attorney with over 20 years experience and a partner at Bird & Bird, one of the leading law firms in the IP field in Europe. Ms. Fuller's practice focuses on international life sciences. And before joining Bird & Bird, Ms. Fuller spent 16 years in Switzerland, where she worked for the WHO as technical and product development officer and at a biotech and pharmaceutical consultancy firm as general counsel and director of legal affairs. I once again welcome you and thank you for being here. Without further ado, I leave the floor to Professor Rai.
Okay. Just need to pull up the slides. Let's get this out of your way. Thank you. So great. Thank you for coming. And for those of you who are in my patent law class right now, you'll get a little bit of review. I'll try not to repeat too much of what some of you have already learned. This will be at a slightly higher level with, I hope, a little more of the policy and politics thrown in. So I'm going to talk, as Dan indicated, about the American Invents Act, the lead up to it, and also the accompanying judicial patent reform, quote unquote, that took place in the US. The patent law system is very much a common law system as well as a statutory system, and so the courts do a lot of reform on their own, independent of what Congress may or may not do. And the interaction between Congress and the courts is always very interesting to observe, and it certainly was a very, very interesting interaction in the run-up to the American Invents Act. So let me just start off with a really quick history. I'll start off with the history, then talk about some key provisions, And then also talk about what comes next, because believe it or not, people are already thinking that we need more patent reform. Whether Congress will be in the mood to do anything along those lines, whether it can do anything at all in its current polarized state is unclear. But Congress may do something, and the courts certainly are continuing to work their way through a bunch of cases that could have really dramatic effects on the patent law in the U.S. So a little bit on what comes next at the end. Try to get this all done in 20 minutes so we have time for Ms. Fuller, and then I hope lots of time for questions. Okay, so history. So there's been at least 10 years of complaining, probably over 10 years of complaining, but at least 10 years of complaining about the quality of issued U.S. patents, whether they're valid and whether the validity standards are actually high quality enough. In other words, have the validity standards been too low? There was a report by the Federal Trade Commission back in 2003 that said that the validity standards were actually too low, that obviousness was too liberal a standard, especially in software and business methods. And so as a consequence, the PTO was pursuant to Federal Circuit case law, Federal Circuit being the relevant patent court, was forced to grant a lot of patents on stuff that was obvious. So it spent a lot of time sort of at least implicitly and to some extent explicitly urging the Federal Circuit to change its ways, or perhaps even the Supreme Court to take a look at the obviousness question. And also it spent a lot of time in the report talking about the possibility of having post-grant validity challenges at the PTO itself as opposed to in the courts, because for a variety of reasons that we can get into, there are reasons to believe that invalid patents won't be challenged in the courts for collective action barrier reasons in particular. And so the FTC report recommended post-grant administrative review proceedings that are cheaper than judicial invalidation proceedings. It also, perhaps most dramatically, recommended changing the current presumption of validity with respect to issued patents from the current standard, which is that the challenger has to prove a patent invalid by clear and convincing evidence. It recommended changing that to just a mere preponderance of the evidence of the standard, so 51%, a standard similar to that used in other civil litigation. The National Academies issued a similar study in 2004, a little more modest in that it didn't recommend changing the presumption of validity, but similar in other respects. And even the American Intellectual Property Law Association, which is often seen as a somewhat conservative organization in the sense of not wanting things to change very much in the intellectual property laws, offered a qualified endorsement, although there was some controversy over the specifics of when post-grant should be available, and that controversy continued actually up to the final legislation enactment. So that's as to patent validity and quality. There was also a lot of controversy over remedies. Starting around 2005 or so, we began to see a fair number of large damage awards against large IT companies in particular. And we also began to see the emergence of the so-called non-practicing entity and non-practicing entity suits of a variety of sorts, the most prominent at that time being the one brought against the maker of the Blackberry on a small portion of the Blackberry apparatus. That suit on that tiny patent, which represented only a small component of the Blackberry apparatus, nonetheless caused Blackberry to settle for $600 million. In the shadow of a pending injunction that would have taken the Blackberry off the market even for a few weeks. Now, these days the Blackberry is all, yesterday's news and obsolete, but then it was the hot mobile device, and everyone in Congress was using it. So all of a sudden, Congress got interested when they thought their Blackberries would be taken away from them. So the remedies issue also began to catch the attention of Congress at that point, along with the FTC and NAS reports on validity and quality. The Federal Circuit had set a very low threshold for injunctive relief, which was why the remedies issue was particularly salient in the RIM case. And for permanent injunctive relief, if the patent was found valid and infringed, the CFC had basically said it was automatic. So there began to be, around 2005, a lot of proposals, at least in the air, if not on paper, about legislative fixes on remedies, including the idea of apportionment, i.e., requiring judges in cases where patents covered only a small proportion of the technology in the final product to specifically allocate the portion of value contributed by the patent. So that's history. There was also a little bit of parallel Supreme Court history going on at the same time. A bunch of cases were decided as Congress was beginning to think about proposed legislation. A bunch of cases were decided that diffused the tension somewhat and diffused the pressure, quite frankly, somewhat as well. KSR versus Teleflex, the second case down, quite explicitly took up the recommendation of the FTC and NIS reports and basically really dramatically raised the non-obviousness standard for determining whether a patent should be issued, basically following what the FTC and the NIS had said, and even, I believe, citing the reports. The eBay case from 2006 diffused tensions as well by taking away this permanent injunctive relief approach, at least in cases where the patent was found valid and infringed that the Federal Circuit had enunciated. There were some other cases as well that we can talk about, MedImmune and LabCorp, that helped to reduce some of the tension. Nonetheless, there was still enough momentum that we did get the America Invents Act eventually, but it was a more modest bill, I think, in significant part because the Supreme Court case law diffused the tension somewhat. It was also a more modest bill, quite frankly, because even in the context of patents, which are a relatively bipartisan issue along the Democratic-Republican lines, there was nonetheless a lot of interest group fighting, and the set of interest groups that got the biggest headlines was biotech and pharma versus information technology, with the former group being seen as very pro-patent and the latter group being seen as less so. But there were also tensions between small companies and large firms, and lots of other interest group controversy in the mix that caused the bill to be quite modest, particularly on remedies. And I say this as somebody who worked quite extensively, as Dan has graciously mentioned, on the bill. I think at the end of the day, it's still a pretty modest bill, although I think it's important nonetheless. So the big changes in the bill are first inventor to file, which partially meets the goal of harmonization advocates, because most other countries around the world have a first to file system. First inventor to file is not exactly the same, but it gets us closer. The Postgrant review, which was the part that I was most excited about, was, I think, resulted in a compromise that I think is less than ideal, but at least it's a step forward. And as I'll say at the very end, there may be some momentum to expand the scope of Postgrant review in the not too distant future. Okay, so first inventor to file. So this is a slide that the students in my class, my patent law class, have seen, and it may be too much in the weeds for this audience, but basically what we have is a first to file system, but with a major exception, and the major exception is the first one. And that is that if the second filer can win if it was the first to publicly disclose the invention. So it could be called, as I've said to my patent law students, a first to publicly disclose and then file within 1 year system, which is quite different from what we have in other countries. So how much harmonization we'll get is less entirely clear, although outside of universities and maybe some small companies, I don't know that the public disclosure option will be utilized that much. So that's first inventor to file. Implicit in that public disclosure idea are various types of grace periods. The public disclosure grace period is the second bullet point. The first filer gets additional grace with respect to disclosure by others if it makes the public disclosure first. So in other words, if you make a public disclosure before somebody else does, even if they file first, you still win. The first grace period is a little more murky in some respects, although frankly the second grace period is a little bit murky as well for a variety of reasons. But you probably have a grace period of 1 year with respect to your own disclosures, including sales and uses. There's some open questions, and that's what I mean by murkiness. With respect to the grace period, precisely how much public disclosure one has to have to knock out a later disclosure is not clear. The PTO just recently issued some guidelines on the question, which are not law because the PTO doesn't have rulemaking authority, but the PTO has not been, the universities have not been happy with what the PTO has said, but we'll see what the Federal Circuit says. Another big open question is whether the old doctrine that existed pre-AIA that prohibited trade secret use for more than a year before one applied for a patent, whether that's been overruled. There's a lot of controversy over that question as well. Then there are the new administrative proceedings. These are all, broadly speaking, post-grant review proceedings, but more specifically, there's inter partes review and something that's specifically designated post-grant review. I'm going to focus on those two proceedings. There are two other proceedings that are worthy of mention, but for reasons of time, I won't go into them. There's the covered business method proceeding that is supposed to specifically target what some in Congress thought were the profusion of bad business method patents that issued in the late 1990s, early part of this century. And that's a pretty robust procedure. And there's also supplemental examination, which is intended to deal with the issue of inequitable conduct. And those two are big for those who are kind of in the weeds of patents, but so I'm happy to talk about them in the Q&A, but the first two is what I'm going to focus on. So these two proceedings are supposed to follow up on many people's suggestions that what we really need is low-cost mechanisms for invalidating bad patents in the patent office itself, as opposed to spending millions of dollars, companies having to spend millions of dollars invalidating them in the courts. The average court case easily costs in the millions of dollars if one wants to litigate it, and to the point of actually invalidating a patent. So the inter partes review, which has been effective for a few months now, is one aspect of what was intended to address people, the overwhelming sense that we needed cheaper ways to invalidate patents. One limitation of the proceeding is that it's limited to invalidation based on prior art. One can be granted inter partes review so long as one shows a reasonable likelihood of prevailing with respect to one claim, but it's limited to prior art. So it's limited in that sense. On the other hand, it is available through the life of the patent. So there's the potential for lots of interactions with judicial proceedings. And we haven't seen how all of this is going to play out because this has only been in place for a few months yet. But this is going to be very interesting for purposes of thinking about future judicial administrative interactions on the question of validity. So it's supposed to be concluded within 1 year. There was a prior inter partes re-examination in the patent office, but that was notoriously slow, and so district courts basically didn't know about it, never paid any attention to it. These proceedings are supposed to be concluded in 1 year, and the office has substantially revised the court that would take these proceedings. So there is a realistic possibility that they could be concluded in a year. As a consequence, I think district courts are more likely to grant stays of any corresponding Article III litigation because a stay shouldn't delay proceedings too much. And in addition, and this is a little bit in the weeds, but it's interesting, because of various Federal Circuit cases, it's pretty clear that the PTO can subsequently invalidate a patent that a court has deemed not invalid. And that means that a failure to grant a stay may just lead the court's action to be ultimately be mooted by a later PTO decision. So I think district courts will be inclined to grant stays. I've talked to sufficient numbers of district court judges now that I'm more confident of that prediction. That said, whether these proceedings will be used is less clear, and thus far there hasn't been a rapid rush to the Patent Office, to put it mildly, to use them. And that's because of serious estoppel effects. Basically, any prior art question that was raised or reasonably could have been raised before the PTO cannot be raised by the defendant in Article 3 litigation. So you really have to trust the administrative proceeding to get it right in order to invoke it. And whether people will trust the administrative proceedings enough is not entirely clear. So the estoppel question is a big one. Then there's post-grant review, which is the most robust procedure in terms of what one can raise, and it's the procedure I have for a very long time been most interested in. In terms of breadth of what can be raised, that is quite significant. So any ground can be raised that will make it more likely than not that the petitioner will prevail with respect to one or more claims. And interestingly, the petition can also be granted if it raises a novel or unsettled legal question that is important to lots of patent applications. So one can use post-grant review as a mechanism to bring test cases before the Patent Office. The constraint on post-grant review is that it's only available 9 months after grant. And so 9 months is not a whole lot of time to figure out whether a patent is the sort of thing that you want to oppose. That said, perhaps it might be enough time to, if one is just interested in bringing a test case, the Googles of the world, I think, may well be interested in just bringing test cases using this particular post-grant review procedure on novel and unsettled legal questions, like questions of patentable subject matter and also Section 112. So what happens post, it's not going to be exactly post March 16th. It only applies to patents with an effective filing date of March 16th, 2013 or after. So it'll be a few months down the line before we see, or maybe even a few years down the line before we see post-grant review being used, if at all. But if it is used to raise these novel or unsettled legal questions, it'll be, I think, a very interesting mechanism for the PTO to increase its power. Again, though, we have an estoppel problem with PGR. Any issue that reasonably could have been raised, one is estopped with respect to asserting in a subsequent Article 3 litigation. And so the argument with these estoppel provisions is that they put a target on the back of the entity that would use an administrative proceeding, because that means that if they lose, then they're automatically out, basically, with respect to most arguments, if not all arguments, they could make in court. There's a lot, so that's post-grant review proceedings. A couple of points that I'll just pass really quickly over for reasons of time, although we can certainly debate them and discuss them further in the Q&A. There's a lot in the AIA that's good with respect to ending discrimination against foreign prior art. So it used to be the case that, well, and it is still the case till March 16th, that foreign prior art that's not written down was discriminated against, and that will no longer be the case post March 16th. So the notorious Hilmer doctrine has also been overruled, and we can talk about the details of that. My patent law students have gotten those 2 slides, so if those are familiar to you, some of you, that's because you saw them in patent law. There's also, and this is more minor, but important for the work of the Patent Office, which is sort of something that is near and dear to my heart since I was there for a while. There's also some ability for the PTO to control its budget a lot better, although, to be frank, the PTO hasn't used its new authority, I think, as effectively as it could have, at least thus far. So what's next? Well, the patent troll issue is still very alive. Troll is, of course, the pejorative word for NPEs. There was a small reform in the American Invents Act that was supposed to help with the NPE question, in that the reform was supposed to reduce the incentive for NPEs to bring suit by disallowing them from suing, for example, 10 companies all at once on the same patent So joinder was made much more difficult. But nonetheless, it appears that NPE litigation continues to be more than half of all patent litigation in the United States. So that's pretty dramatic. Dramatic enough that President Obama has mentioned the issue just recently in public, and that has caused all sorts of speculation as to what he's up to in thinking about this. Most of these patents are software patents, so software patents are particularly on people's minds. Just yesterday I was up in New York at a software patent roundtable that the PTO was putting on. The PTO is thinking about what more it can do about software patents, particularly software patents that claim functionally, make broad functional claims. There is perhaps some congressional interest in looking at the estoppel issue with respect to these the broad estoppel provision, in the particular in the post-grant review and inter partes review proceedings, to see whether that could be changed so as to address what some fear is the chilling effect of those provisions. There is a thought that maybe we need to extend post-grant review further to over the whole life of the patent, or at least for software patents do so, because basically with business method patents what we have is a robust post-grant review over the life of the patent, and the thought, at least that was just being discussed by several people at the roundtable yesterday, was that maybe that should be extended by Congress into software more generally. And then we have a whole slew of 101 and 112 issues at the courts and at the PTO that will continue to be the subject of lots of controversy and litigation. So even though a lot has been done with the AIA, a lot remains to be done, and I think we'll continue to see lots of controversy going forward. So, you know, to be continued. Thanks very much.
While he's getting that set up, I just want to thank Professor Rai and also Dan for organizing it and making it possible for me to be here. Have you got that pulled up? Just, how do I do this? Ah, there we are. Okay. First of all, I'll just sort of issue a disclaimer. I'm a life sciences attorney. I work in the IP division of Bird & Bird, which is a pretty well-known European and Asian intellectual property law firm. I do primarily pharmaceutical and biotech work, having done a lot of work sort of in the trenches with regulatory agencies, but there's a lot of overlap on regulatory issues, which I'll go into a little bit after this presentation if there's time, particularly with regard to supplementary protection certificates, different versions of exclusivity, data, market, orphan exclusivity, etc. And the idea is to give you some background on the current state of play in terms of how variegated and confusing the patent litigation is in the EU. And if there are any questions that I cannot answer, I'll be happy to get back to you on those. But then what I'll be focusing on, try to spend more time on, is the sort of a discussion of what has been proposed and what is the state of play with the proposed unitary patent and that which is sort of joined at the hip with it, which is yet again another attempt at a unified patent court in Europe. So with that, I'll proceed. The subtitles that I had considered for this were So Near and Yet So Far, and the other one was Don't Hold Your Breath, because there is a lot to do before this actually comes into play, because there are a lot of political, cultural, and big historical challenges to being able to pull this off. So that's what I hope to be doing. Alison Brimelow, the ex-president of the EPO, actually called the Unified Patent Court a vanity project because she saw it as a political, it was a political vehicle. I think that's a little bit unfair, but there is certainly an aspect of the efforts that are going through and some of the efforts to impede the process that do make that not an entirely unfair thing to say. So going into what happens at present in Europe, there are multiple types of patents, each with only the national effect. You also have national designations for European patents, and but then in that case you're capable of decentralized opposition within 9 months of grant of the patent. You have multiple jurisdictions. There's at least one court in each country, and so you have international variability, and you also have intranational variability on procedural and on substantive issues. So it gets quite confusing. Usually it's applying with national effect the same black letter substantive law. I say that usually. That is not a hard and fast rule. Sometimes there are subtly different ways of interpreting things. There are also different, as I said before, widely varying procedural regimes. And there are also different approaches with regard to reliefs and remedies. And when you multiply that across all the countries in the European Union, you can see that this could get very confusing indeed, and it does. So what happens at present in Europe? There are a few statistics to look at. First and foremost, it is a much more opaque system than I am given to understand is the case in the U.S., and data is very hard to come by. The national systems do not provide as much information, and there's nothing equivalent in the U.S., in the EU to the U.S. PACER system. There's a lot of anecdotal reporting. There's a lot of incomplete reporting. There's a lot of self-serving reporting, and there's a lot of straight guesswork. And it is important to realize that a lot of what is being dealt with is unknowns, and that leads to further confusion, and it is part of why there have been so many efforts to get a unified patent system in place. There are recent efforts that have been really sort of valiant attempts to get to grips with with such data as are available. And I've given you the websites for them here. I think this will be posted somewhere that you'll all have access to it. If not, send me an email and I'll send it to you. And my email is on the front and back page of this. Then there is a promising attempt at reliable and transparent information that on never before compiled data sets over a 10-year period for 9,000 patent decisions across 7 European countries. The Harhoff, the first of the ones that I mentioned, goes through what are deemed major jurisdictions, Germany, France, Italy, the Netherlands, Sweden, and the UK, and outlines how many cases there are. But then you have to query, a lot of times you're looking at apples and oranges. What is, number one, how they only, it's only as valid as the reporting that they get from the courts in question. And what is meant by a case? How far do you take the case? Do you just file the case? Do you settle the case out of court? Some countries said yes, some said no. And in Germany, particularly, when cases that begin with multiple patents tend to divide them into separate cases, so that could skew your figures very badly. So again, you've got an apples and oranges issue. Again, how many of these are actually fought out in the courts? Again, going on the reasons for the differences in the European patent litigation, there's differences in substantive law as to infringement, and I'll be discussing that later with the regulations 6 and 8 of the proposed patent regulation. And this is despite Article 69 of the European Patent Convention and its protocol. It is slowly being resolved. Germany and the UK, or Great Britain, and I should say Great Britain because it gets tangled up with Ireland and it gets tangled up with Scotland, so it gets more confusing still, are trying to get their approaches to converge, excuse me. But you get all sorts of wrinkles that create confusion. For example, reference to equivalent has not translated well into other jurisdictions. You get differences in substantive law on validity, despite again, the European Patent Convention, which is now, was 1973, now it's 2000. Then there is, Germany is coming to approach novelty in line with other national jurisdictions in Europe, but Germany is an extremely large player in this area, and they have a very, very strong tradition of approaching their patent litigation in a given way, and they don't see that much reason to move from that position. You also have procedural differences. Again, the split system in Austria and Germany, you get differences in attitude towards interim remedies. Then you get in the UK clear the path procedures, and that's particularly in the pharma area. And that's also freedom to operate. And then again, you have differences in remedies. So there are some primarily procedural reasons for differences. This is going over a little bit what I've said before, but there's more. There's structure of the court system, whether it's split or not. The degree of the specialization of the judges in questions varies enormously across Europe. So some of them are highly sophisticated. Some of them are not sophisticated. They are not patent specialists, and they're not dedicated patent courts. So you get a lot of variation. The appellate structure is different in various countries, and the ability to introduce new evidence at the appellate level varies dramatically. So you can see that would create a lot of difficulty and a highly variegated and atomized system. And to operate multi-jurisdictional litigations in Europe is quite a large task, which is not something that Bird complains about a great deal. I think it has to be said. For there's also some variety on the scope for use of criminal law and customs provisions, and that varies nationally. You also get forum shopping within jurisdictions. That's that national variability that I was referring to, and I'll be talking about that again. There are differences in what actions can be brought. There are differences in standing. There are differences in evidence gathering. There's differences in the confidentiality of evidence once it has been made part of the court record. There are huge differences in costs, and I'll be discussing that as well. And then there are attitudes on granting pan-European relief. So just briefly, and again, this is an area I am in the very, very fortunate position of being largely a non-contentious IP attorney with about 50 scary litigators right behind me. So I'm relying on them, and they take over when it gets down into the details at this level. But I have this on good authority and this refers to the differences in who is able to sue in infringement actions. For example, in Germany, for example, you can allow the supplier of a claimed component outside Germany that such supplier knows will be used in a product sold by another in Germany, and that can be their German proceedings can be brought in that situation as an infringement action. Revocation actions cannot be brought on German designations of European patents that are under oppositions. There's a difference, huge differences in the standing that has to be shown in order to initiate an action. In the UK, you might have no standing. You might even be a straw man. In the Netherlands, have been prepared to grant a declaration of obviousness on a pending divisional European application that was about to be granted, and the UK courts have held that they had the jurisdiction to do so. And then there are differences also on declarations of non-infringement, and I'll be discussing that a little bit later on. Again, splitting up issues. There are different. You have the scope. There's the scope to deal with preliminary issues, but you compare the English courts on preliminary attitude towards preliminary issues, which is very flexible and almost invariably bifurcates between liability and relief, as opposed to the German infringement courts of applications to stay for whatever reason, which cannot be determined before the full hearing, and that includes validity. So the extent to which cases must be set out fully in advance, again, varies country to country. In Germany, you've got to have everything fully briefed in advance. Whereas in Spanish procedure, it does not allow for any new arguments or proofs or any information to be added during the course of the proceedings. So it gets very difficult because you have to know what scope does one have to litigate and when in order to initiate part of the litigation, and then you give up the possibility of looking at all of the issues at a later date. So you can lose the ability. So it's a strategic decision. There is a difference with regard to speed to resolution on the merits and the attitude, as I said, to interim relief. And there's a difference in scope, and I've outlined some cases for you here. In the interest of time, I'm just going to leave this to you to see that there are some differences. I think you guys pretty much have the points. But there are cultural differences as well in terms of the urgency, the idea towards the need for urgency. There are dramatic cultural differences. And running throughout this idea is that there is a very strong resistance towards the creation of anything approaching the United States of Europe. It is something that you are dealing with fiercely proud people with long cultures of their own ways of dealing with intellectual property issues, and they do not come together well or without a lot of pressure to do so. And there is a lot of financial pressure to do so, but it's not something that is done lightly. To complicate matters further, well, there's some differences also in evidence gathering. Again, you've got some, the most notable example is that disclosure in the course of proceeding remains in Europe uniquely true in England and in English and in Irish courts, and that is not the case elsewhere. You've got issues with regard to the preservation of confidentiality of documents. And so that's another area where you have to be extraordinarily careful. Then within national jurisdictions, you've got, let's see, did I miss a thing? Oops, within national jurisdictions. Most patent litigation tends to be concentrated within one or two courts within a single national jurisdiction, even when many of those courts might have jurisdiction. In the UK, for example, you'll get attempts to use the Scottish courts instead of the English patent courts, and there are differences in cost recoveries for liability and with regard to damages. And then you get competition and I guess some forum shopping in infringement courts in Germany. And the differences are often reflected in the speed of the court action and the degree of expertise of the judges. That cannot be overstated. There's an enormous variability there. And there are even differences on procedural issues. For example, between the Dusseldorf and the Mannheim courts and the Karlsruhe courts in Germany with regard to FRAND defenses. There are a lot of, they disagree even among themselves, even within the country. The costs also vary enormously. And there is little, again, very little solid data on this and a lot of conjecture. Whereas, for example, in Germany, where the costs associated with nullity suits are higher than the quoted costs for infringement actions. There's a little bit of bait and switch going on. It's generally recognized that the UK is the most expensive of the major jurisdictions, but that's been called into question. And again, you might go into this is the Jackson Review, quotes data from one firm, again, not Bird and Bird, relating to 15 large IP cases which were settled and 3 which were taken to first instance between 1999 and 2007. And the costs were between $197,000 to $1.541 million pounds. Again, pounds, and that's at then current hourly rates, which were at that point an average of £697,000. So you can see how this could begin to add up. and note the dates there. That's 1999 to 2007. But then when you compare the costs actually incurred in competing jurisdictions where there are forced disclosures under cost recovery orders, and you see that sometimes the numbers, they're not as high as in the UK, they are quite substantial. And the court fees in Germany are not included in the references to the Tiefenbacher and the Ratio Farm cases, and that can run into the hundreds of thousands of euros. So it's important to take those, to realize that, again, very often in Europe you're looking at apples and oranges. So that's sort of the past or the current situation, which I think we could all agree is kind of a mess. And so yet in another effort to clear up this confusion, there has been a proposal, and again it is a proposal, for a unitary patent and a unified patent court. And there's some very recent developments in that area, but there's a long way to go. So the scope, just to give you a brief overview, and I do so largely, partially for reasons of time, but also partially because it's going to change. So you're going to need to look at this again anyway if you go into this area. The scope of what is also called the patents package, because this is a two-component package, is that the Unified Patent Court will apply to the new unitary patent, which is to be granted by the EPO. It's to have effect for all of the European Union, with the exception of Spain and Italy. And I'll come back to that, why, in a little bit later. There will also be national designations for European patents or bundle patents granted by the EPO, but they will be subject to opt-out. And single judgments applying to unitary patents or to all designations of bundle patents. It will not apply to national patents or utility models. It will not apply to national designations of European patents outside the EU, or for Italy, or for Spain, or for 7 years to national designations of existing European patents where patentees have opted out. So it's important to realize that there are many ways for patentees to opt out of this system, which kind of renders it, possibly renders it, depending on how this shakes out, could render it a paper tiger. So there's something to be considered there. I'm going to give you a bit of the history of what has happened and the previous attempts that have been made in this area, and which will help you to understand why there's a bit of skepticism about this moving forward. In 1975, 1985, and 1989, there were community patent conventions, none of which came into force. In 1999, the European Patent Litigation Agreement, it was an initiative to bundle European patents. And then in 2000, there was the Commission's proposed regulation on a community patent. Notice that the difference, it is now called the unitary patent and not the community patent, because they couldn't get everybody in the community to agree. So they just changed the name. For 9 years, between 2001 and 2010, there was work on the European Patent Litigation Agreement. There were Commission challenges to this agreement. And then there were efforts on the part of the Commission to integrate the EPLA into arrangements for the community patent regime at that time. In 2011, the Court of Justice for the European Union held that a court system that includes non-EU member states is inconsistent with the EU treaties and the countries in question. There were, I believe, and I can double check this if anybody has any queries about this, Switzerland and Turkey. But that was the issue, that it wasn't going to go through because they were non-EU countries in it. Spain and Italy have rejected the proposed linguistic arrangements because of some issues, and those are currently under challenge even after the February 19th signature on the proposed patent package, or the two aspects of it. There's something called enhanced cooperation It's authorized for the regulation establishing the unitary, and again, no longer the community, but the unitary patent. And there were proposed non-EU intergovernmental treaty amongst the 25 EU member states so as to establish the unified patent court, thereby trying to get around the objections that had been raised by at the European Court of Justice. Let's see, where am I? 2012, there was an agreement on, among other things, and there were a lot of things agreed on that day, on the three-way substantive split of the central division, and I'll show you the divisions that have been proposed in this under this treaty in a moment. But in July through November, there were a lot of behind-the-scenes negotiations and a lot of speculation between the European Parliament and the Council, as well as the Commission, as to Articles 6 to 8 of the regulation. This is an ongoing dispute, changing the names of the various articles in question. The suggestion was last June 29th that they be withdrawn. 6 to 8 address substantive law as to non-infringement. And that is an ongoing dispute. In December, there was an opinion on a challenge by Italy and Spain to the use of the enhanced cooperation, because there's a language issue. They don't like the idea that Spain and Italy or Spanish and Italian are, by their reckoning, deemed less important languages. There was publication of the draft rules of procedure. There was an agreement on the regulation. Again, I should have the word agreement in quotes there. And there was a signature on the intergovernmental treaty, or the draft of the intergovernmental treaty. On February 14th, the Council finally got around to announcing a signature date, and that was the signing ceremony, merely to launch the national ratification process. Now it gets difficult. You thought it was difficult before, but now it gets difficult. On the 19th of February, the 24 out of 27 EU member states signed agreements for the patent package, the unitary patent and the unified patent court. And the unified patent court agreement is in fact an intergovernmental treaty, again, to get around that European Court of Justice decision. And the European patent regulations that had already been approved by the EU Council and the EU Parliament. Bulgaria, Poland, and Spain did not sign, though Italy unexpectedly did. Remember that Italy is also challenging this together with Spain at the European Court of Justice as we speak. So it's a little confusing. Notice that a condition this is an agreement to begin the ratification process. A condition precedent to the ratification process is that at least 13 EU member states will sign. And it is important to note that among those three countries are the three big patent countries, France, Germany, and the United Kingdom. The timing of the ratification is unclear, and here it gets, in addition to being murky, it gets politically murky. There is speculation that Germany will refrain from implementation by delaying ratification, at least until after the September German federal elections, which are currently scheduled to take place in September. This could delay implementation until 2016 or arguably 2017. There are some wags that say it will never happen at all. It's very unclear what will happen, though the document itself very optimistically states that it could all be by April 2014. I think most commentators agree that that's optimistic. If the UPC agreement is not ratified by all 25 member states participating in the enhanced cooperation agreed in June 2012, the pact will only be effective in those nations that have ratified it. Again, sort of defanging this thing. If you want to take away the teeth of a thing, you take away the more and more jurisdictions around it. Though there are those that say if you patent in the big three countries, you don't need to patent in all the small countries, which gets to an administrative council problem that I'll be talking about in a minute. in addition, the unitary effect of the underlying patents will only extend to those countries which have approved the UPC agreement, so that the unitary patent, excuse me, I said unified before, the unitary patent and the unified patent court are joined at the hip. So it's important to see that they are really inextricably linked. There's a lot of disagreement among patent professionals as to whether or not this is going to come into effect, or whether it will be, though it's the closest anyone has ever come, if the historical and political and economic impediments are simply too great, and that remains to be seen. The jurisdictional arrangements are intriguing. Again, trying to get all of the compromise that is required to get this sort of legislation and these sorts of regulation through mean that more and more of the unity, which is the ultimate goal, are sacrificed in the nature of in the service of compromise. So it's an ongoing battle that one begins to question if they've actually defanged it too much. If it's just been too, if the political process has damaged it to out of its own relevance. The jurisdictional arrangements are that you will have a court of first instance with 3 judges, and at least one that will include at least one from the central panel, and that can be in one of three areas, one of 3 designations. The first is the central division, and that is split by patent classification. Anything biotech or pharma related will be in London. Anything automotive or mechanical will be based in Munich, and Paris gets everything else, and that is largely computer implemented inventions, information and telecommunications. And that was thought to be a reasonable division or utilization of existing expertise on the ground. You could also have local divisions, and they could have, depending upon the number of, there will be at least 1 per member state, or they have the right to at least 1 per member state. They have the right to up to 4 per member state, depending upon the number of cases filed. So for every additional 100 cases filed, they have the right to a new division. Or, as an alternative to local divisions, you could get countries banding together and forming regional divisions. Interestingly, at the central division, you don't have, they cannot hear infringement actions without the consent of the parties. Again, remember, none of this has been ratified. There are terrible opposition to this within Germany, and German ratification is a condition precedent. So this could all change. With regard to local divisions, it is proposed that they have exclusive jurisdiction over non-infringement and revocation actions. So then you get, so that's at the court of first instance. Then you get the Court of Appeal, which is 5 judges sitting in Luxembourg. And there are a lot of rules about who those judges will be, what the national, how many judges from which country you will have. And then there's the role of the Court of Justice of the European Union. It has no appellate role as such, but, and if you compare, for example, the community trademark, but the degree of their supervision will be dependent to a certain degree on the issue as to Article 6 and Article 8 of the regulation, which is the substantive law with regard to infringement. How am I doing on time? I'm over time. So I'll speed up here. So what substantive law will apply to the unitary patent is unclear. There will be, you'll get problems about, again, bifurcation and how that will be treated. And remember that in Germany, validity tends to be a longer, determinations of validity tend to be a longer process than they tend to be in other courts. So you could have, arguably, a local or a regional court making determinations about non-infringement prior to the German court making a determination as to validity. So you could see that this could lead to all sorts of uncomfortable wrinkles. And the bifurcation will favor the patentees. Just to give you a visual on how it is, who it is that is to be addressing what issues, I've just given you this as a takeaway sort of cheat sheet to keep it all straight to the degree possible within your heads, also just keeping in mind that it could all change because it is proposed. What still needs to happen? Spell checking still needs to happen, apparently. You have to have the ratification process. You have to have a resolution on the legality of using the mechanism of enhanced cooperation to try to sidestep the requirement of unanimity under the EU treaties for measures concerning languages. That's the Italian, Spanish argument that I had mentioned before. That has partially been addressed by the intergovernmental agreement, but it is not at all clear that you can take the European Court of Justice support for granted. And it is unclear whether or not Articles 6 and 8 are going to be taken out. They have been renamed, and there is an enormous political imbroglio that's been going on since last June between the European Commission and the European Parliament. Each feels that the other has reneged on a deal, and so they're not playing nicely in the sandbox to one another. And whether or not it could be that this stalemate is just slows down the process dramatically. And there's a lot of dispute among legal scholars as to whether or not there even should be Articles 6 and 8 or naming by any other name within the regulation. Some problems. There's skepticism on part of large patentees. You've got jurisdictional asymmetry, which favors patentees. Again, the bifurcation issue on infringement and validity. You've got no scope for potential defendants to clear the path, which is much more in use in the UK. You've got jurisdictional asymmetry, which favors the local and the regional courts, thereby defanging the central division. And then you've got the unknown role of the Court of Justice, the European Union, which leads one to think, what would be the role of the appellate court if they can be trumped potentially by the European Court of Justice, and that remains completely unclear. The European patent system, as opposed to the European Court, just a brief overview. When in force, it's to be retroactive for EPC patents granted after the effective date. Again, they can opt out. They can also elect to opt back in after that decision. The Administrative Council has a lot of power under the proposed regulation, and equal power is given to countries, or very, very, perhaps not completely equal power, but a disproportionate degree of power is being given to countries which do not have a lot of authorized patents. So you can see that, again, the German ratification that this would annoy the Germans, and that they would look dimly upon this, so that there is more political backroom work to be done. Because remember that the agreement provides for a minimum maintenance fee, which is, again, as of yet undetermined, to go to each of the countries, and they have no obligation to invest in their patent systems as a result of the receipt of those fees. Again, something which is likely to lead to trouble. So you've got a significant imbalance of power. And just to conclude, as we know, there are differences between and within EU jurisdictions. The devil is in the procedural detail. The substantive law convergence has gone a lot faster than the procedural law convergence. That's particularly between Great Britain and Germany. And the enforcement directive has had only limited effects on procedural convergence. The case law is moving very, very quickly, but it's very hard to get your hands on case law and information in the EU. You do not have the degree of transparency that you have in the U.S. And then there is the idea is that eventually this is likely to come about. But if the goal is simplification and harmonization of an already complex and expensive system, it's not altogether clear that it is going to achieve those goals. Finally, it is a political minefield between German ratification and the very, very bad blood that's going on between the European Parliament and the European Commission. It is, watch this space because things will change. Thank you.
Produced by Duke University, online at duke.edu.